De Palma versus the State Department of Management Services. And we have Mr. Anthony Falzon for the appellant and Mr. Gallus for the appellee. And Mr. Falzon, just to remind you all have 20 minutes aside. And if you could, as the appellant, tell me how much time for rebuttal, we allot up to 5 minutes, okay? Very good, sir.
Thank you very much, Ron, and may it please the court. I represent the appellant, Robert De Palma, and I'd like to reserve 5 minutes for rebuttal.
Very good.
What we're asking the court to do over here is to backdate my client's same-sex marriage to his husband of 30 years to September the 5th of 1990 to allow him to qualify to provide for his husband under option 3 of the state of Florida's retirement system, which would allow him to let his husband continue to receive benefits after his death. That was denied to him when he entered the DROP program in 2014. So essentially, my client worked for 30 years for Pinellas County. When he entered the DROP program in 2014, the parties have stipulated that had gay marriage being allowed in the state of Florida, my client would have been married to his husband. And my client would, by stipulation of the parties, have exercised option 3. The reason he couldn't exercise option 3 was that option 3 is only available to joint annuitants. And by statutory provision, joint annuitants are spouses. And under Florida's Defense of Marriage Act, which was then in force, spouses could only be same-sex spouses. You couldn't have recognition of could only be opposite-sex spouses. You couldn't have recognition of a same-sex marriage. Now, there is a solution to that, and it's a solution that's being applied across the country, especially in jurisdictions where there is common law marriage, but also in other jurisdictions as well. And that is to basically backdate a marriage if the parties can show that they would have been married but for the unconstitutional prohibition on same-sex marriage. And my client can show that. It is undisputed, true testimony, that on September 5th, 1990, he and his husband had a commitment ceremony that was officiated over by a minister of religion, by a Presbyterian minister in their home. They fulfilled all the requirements laid down by Florida law for a valid marriage. They were aged over.
You know, you throughout the brief, you did keep repeating that. And I kept waiting for some sort of statutory site or some sort of site to case law to support that. So, and I didn't find it. So I'm just wondering, what are you relying on to assert that, but for the fact that it was a same-sex marriage, it would have fulfilled all the requirements?
It was the statute is 740, I believe, .07, which says that there are 4 people that are entitled in the state of Florida to officiate over a marriage. One of them is a notary public. The other is a judicial officer, such as yourself. The other would be the clerk of court. And the other would be a minister of religion. So that's the statutory provision I'm requiring on.
So the solemnization statute.
The solemnization statute, exactly. Okay. And that is what happened over here. In addition, they met all the other requirements. They were aged over 18, which have to be. They were not blood relatives. Neither was married to someone else, which would be a disqualifying factor. They had legal mental capacity to contract. They wished to care and support for each other. Had it not been for that prohibition on getting a marriage license in 1990, they would have been married when that solemnization occurred. And that's what I'm asking to be backdated to. And there's a stipulation between the parties. Remember, they say at the time he entered the drop, they would have been married had it been legal to do so, and he would have gone for option 3. There's no question about that. And basically, this backdating of marriage is not something new that we're asking for that only came into effect after Obergefell, although it's been used. There's a long history in this country of backdating marriage. And it's been used to remedy just the sort of injustice that my clients have suffered. The first was to recognize slave marriages. After the Emancipation Proclamation, the marriages between slaves prior to the Emancipation Proclamation were null and void because property couldn't contract a marriage, and that's what slaves were. After the Emancipation Proclamation, various states in the South passed legislation to allow the recognition of those previously illegal slave marriages. Others used common law marriage to backdate those marriages. And I've cited in my brief to a couple of those cases that date back to the 19th century. The second time it was used was after the case of Loving v. Virginia 53 years ago, when the Supreme Court struck down the anti-miscegenation statutes. In that case, you had various states where they looked at the common law marriages and recognized those marriages as being valid marriages. Now,
let me stop you there also, because I understand that the cases that those arise out of. The information release in this case arose out of Brennan. And
Correct.
Brennan did not talk about that. So the department's position, as I understand it, is the scope of the information release was delimited by the Brennan decision. So is it your position that notwithstanding Brennan, the scope of the information release does not fully comport with equal protection and due process? Are you challenging the scope of the information release itself?
That's exactly what I'm doing, Your Honor, because essentially what the department is arguing is that Brennan just gave prospective relief. And that is what the information release was trying to achieve. That's not true, because Brennan there was a need of passing this information release to have prospective relief. By Brennan striking down the prohibition against same-sex marriage, moving forward, anyone entering into the retirement system would be able to choose option number 3. They didn't need an information release. This was giving retroactive relief. And the way it's being interpreted is to legally recognize marriages. What they mean by that is marriages that prior to Brennan were not legally recognized in the state of Florida, because Florida did not recognize marriages contracted out of state. Similarly to the fact that Florida did not recognize this marriage, which had qualified under all the requirements of a valid marriage in Florida, except that it wasn't a marriage between heterosexuals. So it's a false difference, a false dichotomy that they are making here. And just to look at—
So is that a facial challenge then to the information release as opposed to an as-applied challenge?
No, it is an as-applied challenge. It's an as-applied challenge because what I'm challenging here is the requirement that spouses have to be opposite sex spouses, which is implied into the qualifying conditions to be able to elect option 3. So it's an as-applied challenge, and I'm asking you to use your ability under 120.68 to be able to rectify that unconstitutional deprivation. And this is, if you look at the cases that I have cited through, there are many of them around the country. You've got Renolis v. Dueling, Eastern District of Texas, a very well-researched and written opinion in which they backdate a marriage in Texas to allow a surviving spouse to claim under a wrongful death statute. You've got Hard v. Fancher in the 11th Circuit, 2015, again, under Alabama law, backdating to allow a surviving spouse to claim under the wrongful death statute. You've got the case of Hodgson v. Neal, Colorado, allowing retroactive recognition of marriage. And in that case, what was the ceremony that they were relying on? Exchange of rings at an impromptu ceremony in a bar. That was enough in Hodgson v. Neal for there to be a backdating. Gill v. Van Nostrand, the DC case, backdating marriage. And then, of course, the case of Schuett v. FedEx Corporation. All the other cases I've cited to are in common law marriage jurisdictions, unlike Florida. Schuett v. FedEx Corporation is in California, which doesn't recognize common law marriage. What happened there? You had an employee of FedEx Corporation who was in a pension plan. She was dying. She married her spouse, and California still didn't recognize gay marriage in a civil ceremony. The next day she died. 6 days later, the Windsor decision was decided by the Supreme Court, and the court there in California backdated her marriage to the date that she had entered into the civil marriage, when it wasn't even legal in the state of California, and there was no common law marriage because they
that was a separate proceeding, though, pursuant to California statute, correct? I mean, there was a California statute that allowed them to go get a judicial determination backdating, backdating their marriage, right?
They did that
which
first.
We don't have here, correct?
That hasn't happened here, but that's not even necessary. In the case, for instance, of Anderson v. South Dakota, which is almost mirror image of this case, if you read it, in the South Dakota retirement system, you had two police officers who basically didn't make any steps to have solemnization of the relationship. They didn't go out of state. They didn't take any steps to have a blessing or anything that would be recognized under Dakota law. And the court essentially said, we're denying it for that reason. If there had been a solemnization or some sort of act that showed that you wanted to enter into marriage, then that would have made the case different. This is the case where there is that solemnization. There is that act that would have made this a legal marriage under Florida law, had it not been for the unconstitutional deprivation, the unconstitutional restriction on marriage, which has now been removed.
Okay, and I'm sorry to keep interrupting you. It's a very interesting argument, and I want to make sure I understand it. You're not relying on the information release at all.
Well, if my client gets her marriage backdated, that he gets his marriage backdated, then he'll automatically qualify under the information release. That's what I'm trying to achieve here.
Okay.
Just as the plaintiff was trying to do in South Dakota, except they didn't have a solemnization that they could rely on. I do have that here.
Okay, but your argument about backdating arises out of this broader body of case law.
Correct, out of the Constitution itself, because Obergefell needs to be backdated under the Harper decision by Judge Scalia, which says that constitutional rights get backdated, and any unconstitutional provisions have to be remedied, backdated.
You're welcome to go forward, Mr. Falzon, or do you wish to?
No, I'm actually, I welcome your questions. I have basically made my case. It's not that difficult a case to lay out.
And do you think, I guess my question to you, Ms. Falzon, do you think it would make a difference if your client was able to travel to a different state that recognized, same-sex marriage and had the ceremony there and then come back here? Would that make a difference in your analysis?
I don't think it would, because either one, at the time that the DOMA existed in the state of Florida, whether they went out of state to get a meaningless certificate, which wasn't recognized in Florida, or they had, a meaningless religious ceremony that was solemnized relationship, either one was meaningless. Moreover, you have to think about all those people who prior to 2008 entered the retirement system. And at that point, it was only in 2008 that you could actually travel to Massachusetts. Many people do not realize that when Massachusetts legalized same-sex marriage in 2004, the governor there invoked the anti-evasion statutes. Those were the statutes that were applied to prevent interracial couples from the South going north to get their marriage validated in the north and then come back to the south to try and get them recognized. That was invoked against gay people there. They said anyone who comes from a state which doesn't recognize gay marriage, they can't be married here. That only changed in 2008 when they revoked the 1913 anti-evasion statute there. So it leaves out a whole chunk of people who were in long committed relationships, had ceremonies, very common in the gay community, especially in gay churches, to go and get a blessing of your commitment. And when the domestic partnership legislation would pass, people would go and get their domestic partnership recognized as a way of saying it's valid, even if it doesn't mean anything to the state. To me, it's valid. This is my relationship. It gives me certain rights, whether it's a right to go in and see someone in a hospital, which they may be denied by the family. It was a form of recognition. In this case, it was a form that would have been a legal form of recognition had it not been for the unconstitutional provision.
Thank you, Mr. President. Actually, you're about to get into your rebuttal time. Would you like to reserve the remaining?
Yes, thank you, Judge.
Thank you, sir. And can I trouble you to mute your microphone so we get to hear from Mr. Mr. Gallus. Excellent. Mr. Gallus, you may proceed, sir.
Thank you. May it please the court. Sean Gellus, appearing on behalf of the appellee, Florida Department of Management Services Division of Retirement. I'd like to start out, Your Honors, with the first point in our brief, which is the jurisdiction issue and the failure of Mr. Falzone to brief the issue or explain why this case is appropriately before Your Honors now. He did not cite the case in the initial brief, but in the reply brief, the case of Key Haven Associated Enterprise versus the Board of Trustees of the Internal Improvement Trust Fund is cited, 427 Southern 2nd, 153. On page 157 of that case, the Florida Supreme Court lays out the three circumstances in which it is appropriate to exhaust one's administrative remedies while claiming a constitutional challenge. The first two, I believe, are very clearly not implicated here. The first one being the facial constitutionality of a statute authorizing an agency action. The statute is not being challenged here, and Mr. Falzone indicated there is no facial challenge. The second category is the facial constitutionality of an agency rule, adopted to implement a constitutional provision or a statute. Again, no facial challenge, and we are not talking about a statute or a rule. We are talking about an information release, which was released subject to an injunction. And third, in the final category that perhaps Mr. Falzone and Mr. De Palma attempt to proceed under would be number three, the unconstitutionality of the agency's action in implementing a constitutional statute or rule. And the logic behind this seems pretty obvious, Your Honors. If the agency is taking some unconstitutional action in regard to a statute over which it administers, it would seem fruitless for a plaintiff to go to circuit court, request declaratory relief, and have his or her case dismissed for failure to exhaust administrative remedies. However, I don't believe this case fits into any of these exceptions, and I think that is evidenced furthermore by Mr. De Palma's argument that if the marriage is backdated, then he would comply under the release. The department concurs. Mr. De Palma could go to a circuit court of competent jurisdiction. I imagine the defendant would either be the Department of Health, Bureau of Vital Statistics, or perhaps the circuit court or the clerk of court in the jurisdiction where the marriage certificate is held, and would go there and assert that the state of Florida is unconstitutionally putting a date of 2015 on his marriage certificate as opposed to 1990. The department would not be a party to that action. There would be no defense of failure to exhaust administrative remedies. And should Mr. De Palma come to the department with a valid declaratory judgment in hand from a circuit court of competent jurisdiction stating that his marriage occurred in 1990, then there would be no issue. As he indicated, he would be able to comply under the release because he was in a legal marriage at the time he entered retirement. The relief Mr. De Palma is requesting here is far outside the scope of the Department of Management Services. Mr. De Palma came to the DMS, an executive branch agency, and requested that the head of that agency declare that a valid marriage certificate issued in the state of Florida actually said a different date than what was evidenced on the marriage certificate itself. The executive branch does not interpret the Constitution. The executive branch does not pronounce new interpretations to the Constitution. That is, of course, the role of the judiciary. And the Key Haven case here does lay out those circumstances where it is appropriate to raise these issues in an administrative proceeding. But the department believes here there simply is no jurisdiction. And further, Mr. De Palma did not argue in his initial brief why at all we should be here. It seems he's short-circuiting the process by attempting to have a limited hearing at the department, an informal hearing before a hearing officer, not even a member of the judiciary, who issued a recommended order with a foregone conclusion. I do not have jurisdiction here, to come to appeal and ask this court to apparently order the Department of Management Services, the only other party to this action, to backdate a marriage certificate. The Division of Retirement administers Chapter 121, which is the retirement benefits. As part of administering that, it is true that in order to choose option 3, a retiree must be in a legally recognized marriage at the time they retire. Mr. De Palma, by his own admission on page 11 of the record, says, I was not married when I retired. In fact, he even indicated him and his partner, Mr. Holland, decided to delay marriage until it was legal inside the state of Florida. The department had no part in that decision. Nothing the department did influence that decision at all. So for that reason alone, I think that the final order should be affirmed, because there's not a case here by which the Administrative Procedures Act was intended to apply. You're asking the Department of Management Services to backdate a marriage certificate. That is not within its statutory powers. Simply put, Mr. De Palma could have and should have gone to the circuit court. Department would not be a party to that action at all. And then you would have a developed record, discovery, the opportunity for the trial court to make findings, and perhaps even resolve this issue without the need for an appeal, because circuit courts have constitutional authority, whereas the department's informal hearing officer, according to all the case law, clearly does not. Now, putting aside the jurisdiction issue, to the extent this court does find that there may be issues, jurisdiction to proceed, there are 3 independent reasons why the final order should be affirmed, Your Honors. 1, Mr. De Palma did not meet the requirements. 2, it did not violate equal protection, the release. And the 3rd reason is there's no reason to grant an exception, and that has to do with retroactivity. For the first argument, Mr. De Palma did not meet the requirements. Again, the requirements were very clear, that you must be in a legally recognized marriage at the time of retirement. As Mr. De Palma's counsel argued, the Florida DOMA prevented Florida from recognizing out-of-state marriages. The Brenner decision told the Department of Management Services, do not enforce this provision anymore. The Department of Management Services, as an executive branch agency, implemented that through the information release. It was not done pursuant to statute, nor was it done pursuant to any rule. It was solely done pursuant to an injunction. The logic, of course, being that if you were, marriage is marriage. The department was ordered to recognize marriage as marriage, whereas here, Mr. De Palma is saying that the injunction actually required the department to recognize attempted marriages as marriages. And while the ultimate constitutional question on that may be outstanding, the Department of Management Services is not the proper entity to which that order should flow. They are not the entity to backdate a marriage certificate. They are not the ones preventing Mr. De Palma from getting option 3 benefits. It is the fact that his marriage occurred in 2015 and not 1990. And interestingly, Mr. De Palma himself did not believe his marriage occurred in 1990. In the record, it says he was not married until 2015. It was only after the department denied his relief that he came to this court and asserted, no, my marriage actually occurred in 1990. The second reason, the equal protection, I'd like to talk about this. Mr. De Palma raises in his brief that same-sex couples are being treated differently than heterosexual couples. That may have been as a result of the Florida DOMA previously, but in terms of retirement, the statute is facially very clear. A heterosexual person must be married at the time they enter drop in order to name option 3 beneficiary. That is the same requirement that exists today for a same-sex couple. You must be in a marriage. There is no difference. There is no provision allowing heterosexual, you can look through the statutes. There's no provision allowing heterosexual members to come to the division and request a backdated marriage. That simply is not the case. We don't do that. You are either married and there is proof of that, or you are not. So in terms of the equal protection, Mr. De Palma is not similarly situated to other married individuals. His argument would make more sense if perhaps the division or the department were backdating marriages for other individuals, but not him or a class of individuals like him. There is no allegation that's occurring. That's simply not. The issue here is that Mr. De Palma is not similarly situated. He is not and was not in a legally recognized marriage by his own admission. He did not qualify under the release. And Mr. De Palma is now asking this court to read into the Obergefell, the Windsor, and perhaps even the Brennan decisions, language that was never there. Judge Hinkle, the Department of Management Services was a party to that case. Judge Hinkle could have ordered that they attempt going forward to grant retroactive recognition of attempted marriages. The Supreme Court could have done that in Obergefell. They did not. They have not yet at this time. And simply put, as an executive branch agency, the department cannot do that, which the federal courts have not even done or ordered us to do. And lastly, I want to talk about the retroactive application of these injunctions. Mr. De Palma, I think, confuses the issues slightly where, yes, the department took an action that allowed the department to people to change their options retroactively, but that was solely because the department was failing to recognize that which it should have. There was a marriage, it was lawful, and it was accomplished legally in another jurisdiction. And so the executive branch agency at that time made that decision. The record does not show why. We have a limited record, but obviously the decision was made. But there was no retroactive relief in that retroactive attempted marriages or recognition of attempted marriages retroactively. It was recognition of marriage retroactively. Mr. De Palma, again, by his own admission, admits he was not married when he retired. There is nothing in the Brennan decision or any of the other injunctions ordering the department to consider attempted marriages as marriages. And it would be improper, Your Honors, for the executive branch or for the head of our agency to make those decisions. And so, simply put, I don't want to drag on here too long, but I don't believe this case is properly before this court. I think the way that it was presented and brought, Mr. De Palma just presupposes for this court that, no, I have to exhaust my administrative remedies. But if you look at the case law on that, I think that argument is severely undermined by the fact that the department would not be a party in circuit court. There is no need for the department to be a party in circuit court. And as Judge Rothstein noted, that the real issue here seems to be Mr. De Palma is not challenging the release. It's not the release. The release is being used as a mechanism to obtain relief that it otherwise should be, in our opinion, obtained through the normal circuit court constitutional procedure. There is no world where the department would be a party to that declaratory judgment or where they would have standing to say that there was a failure to exhaust administrative remedies. We just would not be a party to that. We do not administer Chapter 741. We only administer Chapter 121 in terms of retirement. So for those reasons, if there's no questions from the panel, Your Honors, I will cede my time.
Very good. Thank you, Mr. Gillis. I appreciate that. And Mr. Falzon, if you'd like to unmute yourself, you have your rebuttal time.
Thank you, Judge. First of all, both types of marriages were attempted marriages in the eyes of the state of Florida, where it was an attempted marriage in some jurisdiction outside of the state that had no applicability in Florida, or an attempted marriage within the state of Florida by having a minister officiate over a ceremony. Both were attempted marriages. There's no difference between the two just because one was done out of state. For the purpose of the state of Florida, until Brennan, both were attempted marriages. I agree with him that the agency did not have jurisdiction at that level to decide on issues of constitutionality or equity. That's why we're here in front of this court. And of course, had I not made this appeal, my client not appealed this, they would be arguing that we failed to exhaust our administrative remedies, defense number one, in any subsequent lawsuits on an as-applies challenge. Important to recognize, the parties stipulate that had marriage been available, they would have been legally married, that they would have gone for option number 3. So they did that. They went and they got legally married. This is the same as the South Dakota case. It's no different. The only difference is that there is a solemnization here that didn't exist in the South Dakota case. Had that solemnization existed in the South Dakota case, they would have been granted that retroactive relief in exactly the same way. It's exactly the same situation. I rest my case if you have no questions.
All right. Well, thank you, Mr. Falzo, and thank you, Mr. Gelson. Thank you all for joining us in this virtual remote oral argument. And this will now conclude the court's docket. So at this time, we will be signing off. Thank you all.
Thank you.